All right, guys, we're going to get started. So welcome to LawPath Legal Webinar, one of 10 webinars that we're doing in a series, all specifically designed for brand new businesses, small and medium businesses, and anyone looking to start a startup out there to get all their legals in order. Now, we've actually done this webinar before, but it was so popular that we thought we'd do it again. Because it really hits a couple of the main issues that you need to be across when you're first starting your business and also when you're running your business, and that is around some mistakes. So the title of today's webinar is 10 Legal Mistakes Small Businesses Make and How to Avoid Them. So my name is Dominic Norwich. I'm Head of Legal here at LawPath, and I am a solicitor. But most importantly, I deal with hundreds of startups every week and hundreds of small businesses every week, taking them through their legal issues and their legal needs. And so I'm really well placed to talk about these issues. And what we've tried to do today is look at the problems that we've seen from our past clients, put it into a nice, concise presentation, and share it with you today so you don't make the same mistakes. Just to give you a little bit about my background, I spent a long time as a commercial lawyer at Minter Ellison, which is a large top-tier firm here in Australia. I've also spent time doing criminal work at Legal Aid and working in the courts. And I've also spent some time overseas at the International Court of Justice. So a really broad background, which again makes, I think anyway, gives me a good position to talk about the legal issues today. So a lot of you are very familiar with LawPath, but obviously having a look at the guest list of today's webinar, there are a few new people. And so let me give you a very quick understanding of what LawPath is. So we are an online legal service and an online legal platform where small to medium businesses can come and sort out all of their legal needs. So that might include legal documentation, that might include speaking to lawyers, that might include registering trademarks, registering companies, sorting out equity in your business, all the way through to questions you might have to lawyers, or we have a huge database of legal articles and legal blogs that are completely free. So it's your one-stop shop really for any of your legal needs. We started about 2.5 years ago, and since then we've grown rapidly. And I think the reason behind that is that there is a real need for legal services out there at a fixed price and at a low cost. And so that's exactly what we provide. We've grown the business now quite significantly. We have about 650 lawyers on the platform. So if you ever have a legal problem or a legal question, or you need to hire a lawyer, you can jump on what we call our marketplace, and you can get 3 fixed price quotes from lawyers all over Australia. We've also grown our client base to, I think it's actually, that number's been updated, it's about 25,000 clients now. So that's 25,000 clients around Australia that have needed legal services and have found what they were looking for on lawpath.com.au. And we have estimated that we've saved about $6 million in legal fees instead of going down the traditional path through traditional process of finding a lawyer. You can come onto the LawPath platform and satisfy your legal needs in a more technology-focused way, and therefore definitely saving yourself whilst you're doing that. So about $6 million saved. And today's 10 legal mistakes, I'll obviously tell you about the mistakes, but more importantly, how to avoid them and how to find the solution online for either a free or no cost, or at least low cost. So Craig Johnson is one of very, very famous lawyer from Silicon Valley. He's helped a lot of startups start their businesses, some of the huge ones such as Facebook, Instagram. Obviously, you always need a lawyer, but he has this saying that he says a lot, and I think it's really, really good to start off with this one, saying starting companies is a lot like launching rockets. If you're a 1/10 of the degree off at launch, you may be 1,000 miles off downrange. What I think he's trying to say there is that obviously you need a really strong foundation when you're first starting off. You need to be setting up yourself correctly from a legal perspective, because those issues that you may face will only get bigger and bigger as you grow. So look, it's not to say you need to go out and spend thousands of dollars on legal services right at the beginning, let's be honest, you've got better things to spend your money on, such as marketing and advertising. So what I want to do today is at least give you the information that you need to know. And what we always say here at LawPath is to do it in a bit of a tiered approach. Don't go out and spend $20,000 on your company structure to start off with. Let's get you set up as cheaply as possible with the right structure. And as your business grows and you take on more risk, then you can obviously bolt on the more legal protection that you need. So as I mentioned before, we see between 20 and 50 new businesses and startups each day. And a lot of them come to us sometimes when it's too late, when they've already made mistakes. It's going to cost a lot of money to fix. So what I want to do today is pull out those 10 most common mistakes and walk you through how you can definitely avoid them. All right, so let's get right into it. The first one is right at the early stage. Now, I know some of you out there already have businesses and you've most likely taken this step, but this is for the people that are thinking about starting their idea or their business and they've just got an idea, and that's to perform your initial searches correctly. And what do I mean when I say that? I mean, you need to check your business names, you need to check your company names, you need to check the IP, and you need to check your domain names. So let's start with the first one. Obviously, checking identical names on ASIC. So when you're starting a business, worst thing you can probably do is start a business with the name of a similar business. I'm not suddenly going to go out and start a search engine called Google, because I'm pretty sure there's already a search engine out there that's going to take all my business away from me. So very, very simply, what you can do is jump on the ASIC website. Now, ASIC stands for Australian Securities and Investment Commission, and this is the government body that regulates all businesses and companies in Australia. And you can do a name search. Now, those screenshots aren't very clear, but it just gives you a bit of an idea of the page that you're looking for. And there's the URL there for you. What you need to do is do a search for the business name that you're thinking of taking on. That will show up whether there are any businesses out there already that are named. And if there are, you may want to have a second think about whether that's a correct name for you. Now, you can go ahead and register an identical business name in some circumstances, but doing a search on this website first is going to put you in a good position to find out whether there is anyone else out there. Now, additionally, you search your company name as well. Now, a bit of a trap for young players is often people think that a company name and a business name is the same, and they're actually not the same. And I think the best way to explain the difference is to use an example. So I'll use an example close to home, which is LawPath. Everybody knows us as LawPath or lawpath.com.au, but our actual company name is LawPath Operations Pty Ltd. So from a legal perspective, our company is a Pty Ltd, and we are trading as our business name, which is LawPath. So you can trade as a company name, but often you might want to have a company name, which is one thing, ABC company, and you may want to use a business name or a trading name for all your advertising. So this is a website, on the ASIC website is where you can do those searches and you can find out if there are any conflicting names. Additionally, if you are a little bit confused and you want some more information, please feel free to give us a call here at LawPath on 1-800-LawPath. Our customer service team field these type of questions all the time and are very, very happy to provide you with free information around your business name. So secondly, it's time to check whether a name has been trademarked. So you can do this with a government body called IP Australia. And I've also got some screenshots here of the website that you need to be looking for. There's the URL there. Now, a trademark is the ability for you to register a name. Now, this is when if there is an identical trademark, this is when you would not be able to use that name. Once someone has registered a trademark, no one else can use that name. So this is an important one to do, and you really definitely need to check this before you decide to go out and print all your advertising or set up your domain or your website. So you'll go to the IP Australia website and you'll use a service that they have, which is called Atmos. That's ATMOSS. Now, you can log in there. Now, one little thing or a little piece of advice is that when you come to the login screen, it will ask for your username and password. Now, you won't have a username or a password, but just underneath, it'll say log in as a guest. You can click on this and it will take you straight in. Now, what I suggest you do is in the search field there, type in the name of your business, and you can double check whether someone else has trademarked that name. Now, if someone else has trademarked that name in the specific class that your business operates, you cannot name your business that name. So that's when you would really need to start thinking about using a different name. Now, one thing to note around trademarks is that they are broken down into 45 different classes. Those classes are made up of goods and services, and you need to choose the class that is most appropriate to the goods or service that you're offering and trademark in that class. So what I mean there is no blanket trademark that you can do that protects your name in every industry. For example, look, we have the trademark LawPath, but we have that trademark in the legal services class. So if there was a producer out there producing milk or eggs, potentially they could call themselves, LawPath in a different class, and it wouldn't conflict with our trademark. Again, can get a little bit confusing when it comes to IP. The LawPath team are always happy to answer your questions around that. So the next, well, very quickly before we finish on number one, obviously this is a no-brainer, but you need to double check the domain names available. Best way to do that is obviously just to search for the name using Google, or jump on GoDaddy and double check that it's not taken. I can't tell you how many times people have registered companies and business names and then gone to register the domain name and found out that it was taken, and then had to use another name, which doesn't really make sense. Or in a worse situation, purchase the domain name, which can go up into the thousands of dollars. So again, starting off very, very early stage. I know some of you are already past this point, but it's very important for you guys with new businesses to double check and do these searches. Obviously completely free, no need for a lawyer at this stage. This is all things you can do at home online. So moving on to number two, which is the non-disclosure agreement. Now, I'm sure a lot of you may have already heard of a non-disclosure agreement, but let me take you through it very quickly. A non-disclosure agreement is an agreement or a document used to safeguard confidential information. So if you want to disclose any kind of confidential information to another party, it's important, and you feel that confidential information is useful and commercial to your business, it's really important that you put them under some kind of agreement that stops them sharing that information. And there's a couple of areas that you really need to look. If you're doing any of the following four, it's when a non-disclosure agreement will be important. The first one is when you're talking to investors. Now, there's a little bit of an exemption in here, and I'll talk about that in a moment. But if you are going out, you are talking to people about your idea, and potentially you don't want them to take your idea, a non-disclosure agreement is a really good document that will protect your idea. It's often a very simple document, only 1 or 2 pages, and it will have the two parties and the purpose of the confidential information is being shared, and it will not allow one or both parties to share that information with anyone else. Now, one thing to note is if you are starting a business and looking for investors, especially venture capital firms or high net worths, they will often have a blanket rule that they do not sign NDAs. So one way to, when you are first going out, don't expect a VC, or don't walk into a VC's office and put a non-disclosure on their desk and say, before I tell you my idea, you need to sign a non-disclosure, because to be honest, it's going to make you look very unprofessional, because it's just known in the industry that non-disclosures are not signed by VCs. Now, the reason behind this is that VCs are out there looking for great ideas, great businesses. They're often looking in the same industries, and they're not going to tie themselves down by signing an NDA with one party. They're not in the business of starting startups. They're in the business of investing in businesses and startups. And so they're not suddenly going to go and take your idea. And so, often it can naturally seem quite unprofessional if you walk in and ask them to put an NDA down. Moving on very quickly, the next one is obviously talking to potential co-founders. Co-founders are all important to brand new businesses. The success rate around single founders to double founders or co-founders is much, much higher. And so it's really important that if you are talking to people about your idea or joining the company, that before you start those negotiations, you ask them to sign a co-founders agreement. Now, this is widely accepted procedure, and it really puts the other person on notice that you are serious about your idea, and that they need to take your idea seriously and not share it with anyone. Same goes if you are speaking to developers or designers. Often, as a solo co-founder or a non-technical co-founder, you will need to go outside your business to get websites and code built. And obviously, you don't want that code being shared. You don't want your idea being shared. So signing an NDA with these people before you start discussing the idea is really important. And lastly, talking to employees. If you are looking to start negotiating with an employee, really good idea before you start that negotiation to sign an NDA. Now, once you have them under an employment agreement, it will have a confidentiality clause in the employment agreement anyway, so you won't need to worry about an NDA then, but it is important at the very beginning to get them under confidentiality clauses. So one thing to note is that NDAs are only effective once signed, so they can't be backdated. Any information you share before an NDA is signed is public knowledge, and they are under no obligation to keep that confidential. So make sure you get the NDA signed as soon as possible. Now, very quickly, a couple of basics around NDAs. There are two types, one-way and mutual. One-way means that the receiver of the information must keep the information confidential. Mutual means the discloser and the receiver must keep confidential. As mentioned, only effective if signed, so you must share before the information is told to the other party. And obviously, it goes without saying that taking additional steps to protect your information as well. Don't be sharing kind of USB drives with all your secret source, or uploading files with all your secret source onto public websites such as Upwork or Freelancer. You need to take practical steps to protect your idea as well. Again, unfortunately, it's not the best resolution for this screenshot, but this is what a basic NDA looks like. As you can see, it is a very simple document, just signed by both parties. And the great thing about an NDA is it is so simple, but it can be so effective when sharing information. All right, number 3, as mentioned before, so important to often have a co-founder in the business. And so not being on the same page as your co-founder can often make or break a brand new business. So does anyone know who this is? Well, this is Ronald Wayne, and he was the third co-founder of Apple. He bought his 10% of Apple in the 70s for $800. And 2 weeks after, he wasn't happy with how the company was going, and he sold it. He sold his 10% for the $800, which now would be worth up over, I think it's something like $30 million. So it's a big mistake, and the reason was he was not on the same page as his co-founders. So really, really important to be, and there's a great way to get on the same page, and that's by using what we call a co-founders agreement. Now, a co-founders agreement is a precursor to a shareholders agreement. So what we find is that a lot of people will be sitting around the pub or at university, or hanging out with their friends, and they'll come up with a great idea, but they're not ready to start a company and incorporate their business yet and sign a shareholders agreement, mostly because it can be quite expensive to do so. But we need to get some kind of commercial agreement in place. So a co-founders agreement is a simple document that sets out who's involved in the idea, how much capital is being inserted into the idea, what the roles and responsibilities are of each person, and also how much equity each person has. Now, one thing I want to stress is that this is a non-binding agreement. Ultimately, you will need to enter a shareholders agreement and incorporate the business, but this is a really good first step. Often you can use this right at the beginning, and then once it's time, and maybe once you've got down the track and you validated the idea a little bit further, you can move on and get a shareholders agreement. So a couple of questions coming through, and I'd like to answer them now. So feel free to ask questions as we go, and I'm happy to stop and answer them very quickly. So one of the questions we've had coming through is, when in talking around NDAs, does that extend to sophisticated investors? So I think the question's relating to the kind of industry practice that investors and VCs will not sign NDAs, and that is correct. High net worth sophisticated investors, they will not sign NDAs, or it is very unlikely that they will sign NDAs. So when you are going out to any of these type of investors, you need to be aware of this. So number 4 is, the mistake is copying and pasting your online terms from another website. So as I'm probably sure you're all aware, on most websites you go to, down in the footer of the home screen, you'll often see some legal documentation that is linked there. And the most common ones are your website terms and conditions and your privacy policy. These are 2 documents that you're required to have on your website. And right at the beginning, we see a lot of clients coming through, and what they'll do is find a business that is similar to theirs, and they'll copy and paste their terms over, and they'll copy and paste them and place them onto their website. Now, look, this might seem like a bit of a shortcut, and if you found a business that has exactly the same business model as you, it does seem like a good solution or a cheap solution. But really, at the end of the day, your business idea is unique. That's why you've moved forward with it. You feel that you have a point of difference. And so therefore, your terms and conditions will need to be unique as well. So there are a couple of ways that you can cost effectively get your own terms and conditions and privacy policy up on your website. And I'll run through those very quickly right now. One we saw recently, we saw a client come through, and they'd actually copied and pasted another company's T's and C's onto their own website, and forgotten to change a couple of the names in the T's and C's. So it actually had the old company's name in their T's and C's, and they were actually getting sued for copyright infringement. So they did not do a control F, control find search very well, and it had come back to bite them very hard. So really important you get your own up and running. And so let me run through very quickly how you can do that. So obviously the first one that I think is really important to have is a privacy policy. Privacy policy is a document that dictates how you collect, use, and store somebody's confidential information. So if you're running a website these days, you're usually collecting things like email addresses, people's names for newsletters. You might be collecting confidential information, and this could be, age or address or phone number. You might also be, if you're running an e-commerce store, collecting credit card information. And so it's really important that you stipulate where that information is being kept, and this is done through a privacy policy. Now, the privacy policy rules, they were updated in 2014, and so if you had a privacy policy on your website previously, it's very important that you update your privacy policy, because there's a few new things in there, particularly around where you store the information and what country the information is stored in. The rules now say that you must explicitly say where the information is being stored. Now, some people might think, look, I'm just running a small website in Australia. The information is only being stored in Australia. What's really important that you check is where the service or your hosting, the hosting on your website, where are the servers kept? They may be kept in America, and therefore the information is being stored offshore, and you need to say that in your privacy policy. So what I'll do, skip forward very quickly, because this is really exciting. It's actually a legal bot that we have just created specifically for privacy policies. So we've created some software, and you can have a natural language conversation with this bot. Her name's Lexi, and she will tell you about your privacy obligations and even go as far as drafting you a free privacy policy. So if you are not, if you don't have a privacy policy as yet, I really recommend that you jump on Lexi. Best way to find Lexi is just in Google, type in LawPath Lexi, and you can jump on there, have a very quick conversation, and the software will draft your privacy policy for you. It will take no more than 5 minutes. I highly recommend that. It's a great example of how technology is helping lawyers, and in some case replacing lawyers. The next document we need to talk about, very quickly before I move on from the privacy policy, is it legally required? Not if your revenue is under $3 million. So I think I can safely say a lot of the people on the webinar today, revenue will be under $3 million. However, clients really expect the information around where their confidential information is being stored. So it's important that you, even though it's not legally required, have a privacy policy on your website, especially from the fact that it's free. So I go ahead and put that up there. It must be linked in the footer of your home page. That's really important to note. All right, the next document I'd like to talk about is the website terms and conditions. Because if you are selling goods and services online, these are legally required. Now, terms and conditions are a legal document that talks about how your business operates, and more importantly, how you sell goods and services, how payment works, how refunds work, how returns work. And under the Australian consumer law, you're required to tell people about this. So the question there, do I need T's and C's? If you are selling goods and services online, you do need T's and C's. Now, one thing to note, very popular recently has been this concept of marketplaces online. So this is where there is a buyer side and a seller side. The best example of that is eBay. If you are running a marketplace online, you will be required to have T's and C's, but there's almost two sets of T's and C's, one for the buyer and one for the seller. So you're most likely, or you will need a lawyer to help you draft those. And I'll talk about that in a moment. And the last document is online terms of use. So this is for a website that is a blog or an information site. So the alternative to if you are selling goods and services online. And this is a document that will talk about your copyright, what people can and cannot do on your website. For example, can they use the images or the copy that you've written on their own website? And I could safely assume that none of you'd like people stealing your content. So it's important that you have a terms of use up on the website. Now, you might be thinking, how can I get all these documents? You can log on to lawpath.com.au, and your first document is always free. We have over 200 legal documents on there. We're not just going to link you to the document and you have to fill it out yourself. We have software that takes you through the document, asks you natural language questions about your business, and then our software generates the document for you. So if you are selling goods and services and you don't have T's and C's, terms and conditions, jump on LawPath, create yourself a free account, and get your free website terms and conditions. Now, as I mentioned before, if you are running a marketplace, the software is not going to be sufficient. They are more complex, marketplace T's and C's. That's when it's time to contact us, and we'll put you in contact with one of our lawyers who can help you draft that document for you. All right, number 5, which is failing to maintain or failing to manage intellectual property. Really, really important aspect. I think this is probably the number one most important thing that we'll talk about today, because so many people make mistakes. When you're starting a brand new business, when you're a startup or a small business, often your idea or your processes are the only thing that you have of value. You don't have cars, you don't have factories, you don't have warehouses. Your idea is the value. And so it is so important that you protect that. And so let me give you a very quick understanding of what intellectual property is. But it describes any kind of intangible asset, such as an invention, a brand, a design, a process. And so your idea at this early stage is a process. And so that's what you need to protect. So you might think, here are some questions that you can ask yourself. Who built your website? So when somebody builds your website, they're creating IP for you. That code or that design is IP. And so it's so important that you own that IP. And the one thing to consider is that IP is only assigned by written agreement. So what that means is anyone that's creating IP for you or your business, there must be a written agreement that assigns that IP over to you. And the main one we see here is around designs and content. Often when you're starting a business, you might jump online and you might engage someone over in India or Pakistan or Russia to create a website for you or create a design for you or a graphic. It is so important that there is a written agreement between you that assigns that IP to your business. Because what I can tell you is that down the track, especially if you are looking to bring on investors, one of the first questions that they will ask is, who owns the IP? Who owns the value in this business? And it is so important that it is the company that owns that IP, because the reality is that they're investing in the company. They're not investing in you. Obviously, they want you to come along for the ride, but they're investing in the company, and so the company must own that. So there's a couple of kind of problems that we see day in, day out here at LawPath, and so I'll cover the two most popular ones. And the first one is the moonlighting problem. So if you're working on your idea or your new business or your startup, but you're currently employed by another company, under your employment agreement, there will most likely be an intellectual property clause in there. And what that will say is that any IP that you create whilst on your company's time or using their resources, such as their computers or their phones, is automatically assigned to that company. So what that means is if you are working on your own idea independently, you need to be really cautious about when and where you're doing that. You need to be working on it in your own time, out of business hours, and on your own computer or your own phone. Just this morning, we've had a case come through LawPath where an employee had a new idea. He went out on his own to create that idea. It's done extremely well, and now his old company has come back and sued for 50% of the profits. And he was under a contract agreement that had an IP clause signing all the IP to the company. So the company has a very good chance of actually coming through with that claim. So really, really important if you are working on your own idea to be doing it on your own time. Now, the second problem that we see is what I like to call the Zuckerberg problem. Everyone's seen the Facebook movie. Everyone knows Mark Zuckerberg. And that is the example that happened there was the Winklevoss twins came up with an idea. They engaged a developer, Mark Zuckerberg, to create that idea. And allegedly, he stole that idea and created Facebook. And so this doesn't just happen in the movies. This doesn't just happen in Silicon Valley. It happens every day, especially down here in Australia, because a lot of the resources we use are offshore. And so if you do have an idea and you look to engage a third party or a developer, it's really important that you have an agreement in place that stipulates what they're doing for you, how much you're paying them, and that the idea and the code is being assigned back to you as they create it. So just before I finish on IP, there's two ways to fix any issues. I know some of you might be thinking, oh no, I engaged a developer in Russia a couple of months ago to build my website and there was no agreement in place. Not to worry, there's a way to get around that. Obviously, firstly, best to, from the start, have an agreement in place, such as a website development agreement or a contractor agreement. But if that hasn't happened, and you need to retrospectively assign the IP, you can use what's called an assignment of IP deed. Now, this is a simple document that lists the two parties and very simply assigns IP from one party to another, often for very low consideration, such as $1. Now, this agreement is available on the LawPath website. You can log on and use the search bar and type in assignment of IP deed. This will bring it up. If you do have any questions, feel free to give our customer service team a call and they can walk you through how it works. So if you are out there thinking, I got a design done last year for my logo and I never had anything in writing, I strongly suggest you use an assignment of IP deed to bring that logo into your business. Now, I say into the business because the assignment of IP deed will be between the third party and your company, not you personally, but your company, because we need to assign that IP into the entity and not to you. So that's really, really important. And I think that leads on really nicely to our next section, which is incorporating a company at the wrong time. So what we often see is somebody will have an idea and they will incorporate their company far too early. And when I say incorporate, I mean register a company with the Australian Securities and Investment Commission, or they might incorporate their company too late. And this is where the IP issue comes in. If you are creating your idea and starting your company and entering into contracts and taking on risk, you need to be doing that as a company and not you personally. Because if you are personally entering into these agreements, then you are personally liable for anything that goes wrong. So when is it time to incorporate a company? I would say it's when you are starting to bring on risk into the business. Now, risk might be in the form of entering into contracts with clients, but it might also be in the form of entering into contracts with employees. From a legal perspective, an employment agreement is seen as a risk because you are entering into an agreement to pay this employee and to be responsible for this employee. So just to recap, if you're entering into any kind of agreements with clients, if you're purchasing any kind of assets, if you're entering into any kind of employment or contractor agreements, that is when it's time to incorporate or register your company. Now, used to be quite difficult to register a company. These days, it's extremely easy, and I'll walk you through the process right now. So as you're most likely all aware, there are 3 types of business structures that you can have here in Australia, with 3 main types. The first one is a sole trader, where you're personally liable for the business. The second is a partnership, effectively 2 sole traders that are both personally liable for the business. And the third is a company. Now, the difference between a company is that it is, in the eyes of the law, a separate legal entity. And therefore, the company takes on the risk, and the company is responsible for anything that goes wrong. Now, you obviously will be the director of the company and are responsible for the day-to-day running of the company, but it's the company that's taking on the risk. And as a director, unless you are negligent, you are often not held accountable for the errors or the issues that happen within the company. Now, point number 4 there is trusts, and I put that on the list because trusts are often used in the formation of a company or the structure of your business. Now, technically, trusts are not a business structure. They are a relationship on how somebody owns shares in a business. So the most common structure is that you will have a trust. That trust will have a trustee, and that trustee will own shares in a company on behalf of that trust. Now, there are a bunch of tax implications that make trusts very, very beneficial. And so what I would say is that if you are thinking of setting up a business and you are thinking of the best structure to use, you do need to get some advice around this. You can speak to a lawyer or an accountant, but using a trust is often the most beneficial from a legal and a tax perspective. So very quickly there, we've touched on what is the best structure. It's definitely a company structure. Obviously, the limited liability issue around risk. There is much better tax concessions if you are a company, to give you a very high level indication of that. If you are running a sole trader or a partnership, you can be taxed, or you will be taxed through your personal income rate, which could be as high as 48.5%. As a company, there is a flat corporate tax rate of 30%. So you can see there that it's already almost an 18% difference in the tax that you will pay. As we've mentioned before, entering into any kind of contracts, taking on any risk needs to be done on behalf of the company and not you personally. Investors, this is a huge one. Investors will not invest in a sole trader or a partnership, or it's very unlikely. And the reason being is that they want to invest in a company. A company is made up of shares, and they can very easily purchase a percentage of those shares. Additionally, you are bringing on new people into the business or new shareholders. Because the company is made up of shares, it's very easy to sell or assign those shares to people. Lastly, disputes. Often disputes in a company are governed by what's called a shareholders agreement, and there are very stringent rules set out in that shareholders agreement how disputes will be made. And lastly, the equity side. It's very easy to sell and buy shares in a company, whereas it's much, much harder to sell or buy a portion of a sole trader or a partnership, almost impossible. So how do you incorporate? As I said, it used to take quite a while. There'd be lots of forms to fill out. It could take up to 2 weeks for your accountant or your lawyer to do it. Now, fortunately, there's some fantastic online solutions. LawPath is one of them, but there are other programs out there. If you go online, the application takes between 5 and 10 minutes. You'll list the directors of the company, the shareholders of the company, how many shares are in that company, and this software will directly talk to ASIC and register your company in a couple of seconds. I think the fastest we see it done here at LawPath, we register tens of companies a day, and we see it done in 2 or 3 seconds at its fastest. Additionally, with these programs, you can also get ABN, TFN, GST, which are all aspects of your new business that you will need to deal with. ABN is your Australian business number, required if you are paying tax. It's issued by the Australian Tax Office. You will need one. One thing to note there, guys, is if you are starting a new company, you cannot use your old ABN. You must have a new ABN for the company. Also, Tax file number, if you are a company, you are required to have a tax file number for tax purposes. That is issued by the ATO. And GST, if you believe your revenue will be over $75,000, you're required to register for GST. And lastly there, guys, this is a quote that we use a lot at LawPath. Don't incorporate a hobby. Incorporate when you are serious about making your business or your startup into a proper business. All right, number 7 is when you have co-founders in the business. This one is a little bit complicated. I do want to touch on it very quickly though. And this is this issue around vesting. So here's the problem. You have 2 founders, they start a business. They each get 50% of the business, which seems fair. However, after 6 months, one of them has a baby and decides to leave and wants nothing to do with the business anymore. What happens? Well, the problem is that that person just walks away with 50% of the business, and the other person is stuck in the business doing 100% of the work for only 50% of the reward. So what's the solution? And that's this idea of vesting. And so if you are starting a new business, it's crucial that you have vesting in place. What vesting means is that co-founders will earn their merit or their shares over a certain period of time. So I think the best way to explain it is to show you a graph. So here you can see this is an industry standard. This is a 4-year vesting with a 1-year cliff. So what this means is for the first year that you're working together, none of you earn any equity. No equity vests. But after the first year, you get 25%. So that would be 25% of the full equity that you're entitled to. In this case, if you were splitting the business 50-50, it would be 25% of your 50%. And then over the next 3 years or 36 months, your equity equally vests. So what this means is that, for example, using the example that we used before, say in month 15, one of the co-founders decides to leave. Out of he has to leave the business. He only leaves with 30% of his equity. So he's earned 30%, so we're happy for him to walk away with it. But what it means is there's another 70% there that can be used if another co-founder comes in. Because if he walked away with his full equity and you needed to bring someone else into the business, it's very hard to incentivize them, knowing that there was a co-founder that had been there originally that wasn't doing anything, but that was getting 50% of the profits or the revenue. So vesting is really, really important. You might ask, why do we have a cliff? The cliff is used so that you don't have people that come and join the business for 3 or 6 months and then leave with small amounts of equity. Before you know it, your cap table at the back of your capital table is going to get extremely messy. And so we put a cliff on there to incentivize people to stay for 12 months. And the last point I'll make is that you might be thinking, well, what happens if I sell the business after 24 months and only 40% of my equity is invested or is vested? And what I'd say there is we use this concept of acceleration. What that means is that if there is an early exit or somebody purchases the business, that your equity automatically accelerates to the 100%. So guys, I know this issue can be a little bit complicated, but it is so important that you put it in place. If you do have any questions, again, feel free to give us a call at LawPath. We're happy to walk you through it, or we can connect you up to some of our lawyers that specialize in this, and they can set out a vesting plan for your business that's really unique for you. Now, guys, we've got about 14 minutes left. I've got 3 more points. I'm going to go through them quite quickly because I want to leave a little bit of time for questions at the end. So the next one is around advisors, advisory boards. So thinking that advisory boards are only for large companies, and they're not. It's so important to have people around you that can guide you, that have gone through it before, that can give you advice. So you can have an advisory board as a small business. Some of the best businesses we see come through LawPath are ones that have strong advisory boards. So you surround yourself with people that have either done it before or built businesses before in other industries, or have connections and channels into investors. Often we see that advisors are the ones that introduce you to your first investor. So you're never too small to have an advisory board. Often you can issue the advisors with small amounts of equity. Now this isn't standard. You don't have to give them any equity. Often we see an advisor getting maybe between 0.2 to 0.5% of a company to be an advisor. And what does that advisor do? You know, at a minimum, they might attend 4 meetings a year and sit in on some of the high-level strategic decisions. Maybe they'll be more involved and they'll check in weekly or monthly with the business to see how you're going. But it's fantastic for you to bounce ideas off. Really, really easy, great for networking, and on the good side, really easy to appoint. On LawPath, there's an advisory board member agreement. It's a very simple agreement that appoints advisors to your company and can issue them with equity if you need it. And so I definitely think about going out and finding people in your communities that have worked in your industry before, or you think would be fantastic assets to the business, and asking them to be advisors. Often people are really chuffed when you ask them to be an advisor in the business. All right, number 9, which is really important. We actually did a survey last year of 1,000 of our startups, and we found that over 60% of them had incorrect contracts for their employees. Employment is under the National Employment Standards, so some really strict rules around employees and contractors in Australia. So you need to make sure that you're really across the right documents to be using. And one of the main issues we see is this difference between contractors and employees. So it's really important that if you treat somebody that's working for you as an employee, they're under an employment agreement, or if they're independent, they're under a contractor agreement. Now, what I would say is that there's a number of factors that come into whether they're an employee or a contractor. But one of the best tools is, and I haven't got the link here, unfortunately, but if you go to the National Employment Standards website, and I think it's called the Employee v Contractor Calculator, what it will do is you will enter in some information about who you're hiring and your business, and it will tell you if they're a contractor or an employee. So I really recommend you do that. And then once you know, you can come to the LawPath website. We have some fantastic employment and contractor agreements on there that can really help you. Additionally, you might want to use our free legal health check. This is a piece of software that we have on our website for free. You answer questions about your business. The software will analyze your kind of legal gaps or what you need, and then it will issue you with a report of all the actions and the documents you need to take. So you could use these for employees, but you could use these for all the documents that I've talked about today and all the actions that I've told you today, because I know there's been a lot of information, but this legal health check will put it all into a report customized for your business. All right, last point today, guys, which is using the wrong lawyer. Now, one thing is that law is a huge area, and it's really important you engage a lawyer that has expertise in your specific area. Now, what I mean by that is there is no point going out to a criminal lawyer or a lawyer that got you off a speeding charge recently in court and asking them to issue equity under an employee share scheme or a shareholders agreement, because they just won't know what they're doing. So it's really important, depending on what you're looking for, that you reach out to the right lawyers. And the reason I mention this is that I would really encourage you to jump onto the LawPath directory. We have over 700 lawyers on that directory, and they all specialize in different areas. And that directory is connected to our marketplace. So if you have a legal issue and you don't know which lawyers to use, you can jump on and create a small brief on our marketplace. It's known as the Quick Quote Marketplace. And within 4 hours, we'll get you 3 fixed price quotes from lawyers that specialize in your area. So the great thing about that is it's all fixed price, so you know exactly how much you're paying, and you find the right lawyer for the issue or the legal problem that you're having. So traditionally, it's been very hard to find lawyers. You have to Google them, you have to go into their offices, you couldn't compare. Whereas this marketplace gives you all the lawyers in one spot with transparent pricing. And more importantly, one of the best features, I think, is that it rates and reviews all of the lawyers. So whenever you use a lawyer through LawPath, you will rate and review them. So you can jump on the directory there and review all the peer-to-peer reviews, and you can find out what other clients have been using and whether they like the lawyer. So guys, we're nearly at the end, but what I want to do right now is offer you, thanks for joining us, and offer you a special discount today. So what we have is a webinar offer, and it is for an annual LawPath subscription for $199. So it's normally $350, so you're saving $150. And this annual subscription is going to give you unlimited access to all of our legal documents for 1 year. It's going to give you access to our legal marketplace with over 700 lawyers on there. It's going to give you access to our legal guides and legal blogs. There's over 800 of them, and they give you information about how to complete legal tasks yourself. So there's a real wealth of knowledge there. It's also going to give you access to our trademark and patent systems and our company incorporation systems. So there's a huge amount of value there. And if you are starting a business, it's a fantastic resource for you. Last thing you want to do is go out and at this early stage, spend thousands of dollars on a lawyer drafting you employment and contractor and NDA agreements. What I can say is for $199, you're going to get unlimited access to all those agreements, plus many, many more. You can come in at any time and create them using our software. They're all stored on your LawPath account in the cloud, so they're accessible from any device. You can go in and edit them. I can say that there's huge value there in getting a LawPath subscription. So that's our offer today, guys, $199. And what we will do is give you unlimited access to the LawPath platform. If you have any questions, feel free to give us a call on 1-800-LawPath, or right there, try.lawpath.com.au/webinar offer is the link to this limited time offer. I'm pretty sure it will only be up for a couple of days. Actually, it expires on Monday. So get in there as quickly as possible. We've had fantastic response to this offer. That's why we're doing it again. So jump on there and get yourself an annual subscription. Now, guys, we did have a couple of questions throughout the webinar, and I'd love to touch on those in the last couple of minutes. As I said before, sometimes it's some of the questions can be quite personal. If you do want to just have a phone call, that is more than welcome to give us a call and talk about it. But there's a couple of questions that have come through, and I'll talk about them now. So one of the questions from Anna is, as a small business, I'm interested to know if LawPath has any information on social media. For instance, are any particular things to be aware of when it comes to this area? Awesome question, Anna, because yes, that is a really common question that we have. So as a small business, really, really important, especially if you are bringing on new people to work in the business, that you have a social media policy. So this is a document that talks about what people can and cannot do in your business around social media. Additionally, there can be some issues around social media when often as a startup, you're looking for validation from other companies, and you might want to put on social media that other clients or larger companies have used you. Very common in the kind of testimonial section. Very, very important that you get permission before you do these from these companies. Last thing you want to do is put up their brand or their logo on your website and then get sued for copyright infringement. We do see it. Now, a really, really good way to get around this is to put in your T's and C's that if someone signs up for your service or buys your goods or your service, that you are allowed to display their logo on your website. So, Anna, if two considerations you need to be across when you're using social media. If you had anything more specific that you wanted to ask, again, give us a call. Happy to answer those. We've got another question here. So, in the example of vesting, while co-founders work in the business to earn their shares over time, who owns the shares? Okay, fantastic. Really, really good idea. Really, really good question. So, if shares are vesting over a certain period of time, what they are most likely, the company owns those shares. So if the shares, as in my example, after 18 months, if one of the co-founders leaves the business, the shares are still owned by the company. So they go back to the company and they can be reissued out to whoever they need to. So what happens is you can do a vesting schedule both ways. You can either, the company owns all the shares, and then as they vest to the shareholder, or we've seen what's quite popular recently is almost reverse vesting. So what that means is that the co-founder or the person that starts the business actually owns all the shares up front, but there's an agreement in place that says if they leave early, they have to give back the shares. So this is often used when you first start a business. Sometimes you incorporate, you issue all the shares with ASIC, and then you say, oh, I want to put investing. And so this agreement is used when you want to take shares back from co-founders. So it's a very, very fair way to do it. There's a couple of lawyers out there that do these agreements for people. We use them all the time. If you have done that, you are in that situation where you registered your company with ASIC, you issued all the shares, and now you're thinking of putting investing, get in contact with us. We'll put you in contact with these lawyers and they can get this kind of document drafted up for you. All right, guys, it's right on 1 o'clock, so I think we'll finish there. I don't think, unless there's any more questions that haven't been answered, we can always get back to you via email if I've missed one. Apologies for that. But lastly, again, have a look at that offer. It is a fantastic offer, $199 for a 12-month LawPath subscription, gives you unlimited access to our whole platform. I really recommend that you jump on that straight away, as it does expire on Monday. All right, guys, thanks for joining us today on the LawPath webinar. As I said, this is number 3 of 10. We've got a lot more fantastic information to provide to you. Keep an eye out on your email for the next one that's coming up, and hope to see you next week. Thanks for joining us.